Good morning, Ms. Harvey.
Good morning, CJ.
How are you?
I'm okay, thank you, CJ, and I trust you are too, and the rest of the
we
commissioners.
are. Thank you. Oh, first, let me just welcome the Judge President of the Labour Courts, JP Mulatlehi, and his team from Netluck, Messrs. Twala and Mkalipi. Good morning, gentlemen. You were here not so long ago.
Yes, CJ.
We have a transcript of that long interview in front of us, so I don't imagine that we will be particularly long with you, if at all. But unless you've done something really bad since we were last year, that would have to raise with you, which I doubt.
I have not, CJ.
Yeah. You are the one-time engineer turned trade unionist turned advocate
That's correct, CJ.
who studied a BSc engineering at Wits, then some years later went on to obtain an LLB cum laude, and then an LLM with distinction.
I thought, if I may, I might explain, as I didn't last time,
Yes,
that rather
please.
unusual pathway. It was really rooted in early experience, accompanying my father from a very early age, who rejected segregation and crossed apartheid's boundaries to work with youth and artists in Soweto and Alexandra. So from the time that I was about 8 or 9 years old, I was accompanying him in those spaces, accompanying him to classes, meetings, poetry readings, and so on. And as a result of that experience as a young person, it became clear to me how artificial the segregated environment of my schooling was, and the artificial environment that other white South Africans were being forced to grow up in. And as a result of that, I made a decision to leave school early. In those days, it was possible to do Standard 9 and Standard 10 in 1 year, so I rolled them in when I was 17. And the one thing that I felt was lacking in my education was the ability to speak an African language, because that seemed to be the last barrier between me and everybody else in our country. So I then went to Botswana in order to immerse myself in a Setswana-speaking environment. It's not an easy language to learn when you are English speaking, because it doesn't just map easily onto English the way another European language might, like French or Italian. And so an immersion in a completely Setswana-speaking environment where nobody could fall back on English was necessary. And while I was there, I joined the ANC in exile. And when I returned to South Africa, the reason that I did the engineering degree was that that was something that the ANC thought would be useful in a future liberated South Africa. But by the time I finished that degree, Chief Justice, we were in the state of emergency. It was 1986. And so after completing my apprenticeship, just to complete the qualification in 1987, Chief Justice, I then went to work for the trade union movement, which at the time was, as you will recall, really the only legal activist form of organization in South Africa. And my earlier experience with working in Botswana and learning basic proficiency in Setswana obviously supported that work, because I was then able to properly communicate with and properly represent workers in the two unions that I worked for, being SACAWU and then the National Union of Metal Workers. So I know a lot of people ask me, how did you move from engineering to law? And that really is the answer. After 94, I then joined the CCMA because I'd had a legal experience, although really paralegal experience without a formal legal training. I'd had that experience representing workers at the industrial courts and in various tribunals. And when they recruited commissioners for the CCMA, they drew us from the ranks of trade unionists, qualified lawyers, and then also a lot of people who had come off the Truth and Reconciliation Commission. So that then explains the pathway, which might otherwise look rather strange.
All right. So you've been a member of the Cape Bar since 2010?
Yes, I think I did pupillage in 2010, Chief Justice. So I think I only became a member at the end of that year.
All right. And you remember of Saslo, panelist of Tokiso, and an arbitrator. Are you an arbitrator, or what is a fellow of the Association of Arbitrators?
It's just an accreditation, really.
Oh, I see.
So I was always an accredited CCMA and Bargaining Council arbitrator, CCMA accredited, but I wanted to expand into commercial arbitration as well, and that requires one to do a course and then to join the association of whatever it was, arbitrators. That wasn't very long lasting. I only did one commercial arbitration, and after that I allowed my membership to lapse because I became more and more drawn in the labor law direction in my practice.
Your practice is mostly focused on labor law.
It is, yes.
And you appear a lot in the labor courts, and you've appeared in big cases, as I understand it, in the Constitutional Court as well.
I've been lucky enough to appear in 2 of those, yes, CJ.
Which ones?
That was the assigned services case and the Dunlop mixing case. The first one to do with the interpretation of Section 198 of the LRA, which deemed precarious labor broker workers to be employed by clients after 3 months. It was the interpretation of that section, which was a new section. And in fact, that was very important to me because as a CCMA commissioner, I had found myself unable properly to reinstate unfairly dismissed workers who had been placed through labor brokers, because the then Section 198 provided that they were employed by the broker and not the client, and the brokers would then say that they couldn't place the worker back at the client. I had a very a sort of wake up when I had a case of a hotel worker who was dismissed for theft, and there was no proof that any theft had taken place other than the guests say so, that he had left something in his room, and she was dismissed merely because she was the cleaner attached to that room. But when it came to applying the primary remedy of reinstatement, the broker explained to me that it couldn't put her back at that hotel, and in fact she would be blacklisted, and so they couldn't use her at any hotel, and therefore that they couldn't reinstate her. And that then brought the unconstitutionality of that section to my attention, and that became the subject of my LLM thesis, the unconstitutionality of that section. That essay won the Ishmael Mohammed Law Reform Essay Prize, and a few years later the law was amended in the way that we all know. But then the interpretation of that amendment was challenged, hence my arguing that assigned services case. And the Dunlop case, as this forum knows, was the one which dealt with derivative misconduct.
The last time you were here, you had acted at the labor court for only, was it 7 weeks?
It was 7 weeks, Chief Justice.
Just remind me, had you had time to write judgments?
I had, Chief Justice, at the time, I believe I had 35 written judgments and I think 3 extempores. But since then, I've had the opportunity to act for a
For how long?
I acted for a further 2 weeks in the 3rd term in the Labour Court in July and August. I also acted for a week in the Western Cape High Court, and I've now been appointed to act for the whole of the 4th term in the Labour Court. So I'm at the end of the 1st week of the 4th term. I think if we add them all up, that comes to, I think it's 11 weeks now, Chief Justice, and by the end of this term, it will be 19 weeks.
All right. And have you produced any further written judgments during this fresh stint?
And in fact, I realized yesterday when I was going through my judgments that I hadn't provided any of the more recent ones. So I emailed them through. I know it was very late. But I've produced, since my last sitting here, another 5 written judgments. In fact, it's 6 with the High Court judgment. And I've given, I think this week, I've given 3 extempore judgments and 1 written judgment, Chief Justice. Right now, I'm sitting with 4 reserved judgments, including one from yesterday.
All right. In addition to being a prolific judgment writer, you have written outside your short judicial career. You've written an essay that was published in the SALJ.
Chief Justice, that was the essay I was referring to on the constitutionality of
Oh, I
Section
thought that
198.
was. Oh, okay.
Yes.
So it was. Oh, your thesis became the article. Oh, I
Yes.
see.
Yes,
Okay.
it did.
All right.
I don't have a lot of academic writings to my name, CJ, as you will see from the questionnaire and
Yes.
the CV. Aside from written judgments and many, many arbitration awards that I've obviously written over the 25 years of being a CCMA commissioner, my only other written work has been contributions to conferences and training sessions. And something I realized when I was going through my papers just in the last 2 or 3 weeks that I haven't even put in my CV was that I made a presentation to a language conference in 1993, one of the many language conferences that was leading up to hopefully establishing a language policy for South Africa post-democracy. And so I argued in that conference paper, as I would today, that English should not be privileged as the primary language either in the country or in the courts. I think we spoke a little bit about that last time I was here, Chief Justice, and I believe that since then you yourself have suggested that the rule about English being the language of courts may well need to be revisited.
All right. You've also been a guest lecturer in the master's program at the University of Cape Town.
Just from time to time, yes.
From time to
CJ.
time, yes. And you train pupils, you've trained pupils, and what's that about recruiting, training, and supporting youth for placement abroad?
Oh, that was in Canada. I was very close to my extended family, and when my father emigrated to Canada in 1997, I followed him with my family, but I couldn't get used to life there, and so I returned. But while I was there, I was working with an organization that was supporting media freedom in the Pacific Rim, and that entailed recruiting and training youth interns. But that was mainly in the area of media studies. In terms of other training, I think my most prolific training has been for the CCMA. I trained several cohorts of new commissioners, which I felt was very important because CCMA commissioners, especially in the early days, were really in a position to deliver, I think what this forum last time I was here named transformative justice. So I've trained a number of those cohorts of commissioners. I've also worked training paralegals and community advice officers and young attorneys in the legal NGOs. And at the bar, I trained as an advocacy trainer and served as a member of faculty training pupils in the method, as well as one pupil who was allocated to me. And more recently, I've worked with juniors, mentoring juniors, both on a co-briefing and a fee-sharing basis. And Chief Justice, since I was last here, I've relocated to Johannesburg. I'm now a member of the Johannesburg Bar. I'm a member of the Maisels group, which has recently established a pro bono initiative which links young advocates with pro bono work. And my role in that initiative now is to assist by mentoring young advocates who take up pro bono cases, because of course people who need pro bono assistance need that assistance to be at a high level of quality. And I think one of the aims of the pro bono project is to ensure that advocates are mentored by people with experience in the particular area of law that they're going to be working in, both for training purposes and to make sure that litigants needing pro bono assistance are well represented.
All right. As I recall, no one had a real quibble with your credentials the last time you were here. Only 2 issues had been raised. One by the BLA that questioned your commitment to the transformation of our society, which I found bizarre, considering that your background as a trade unionist having worked for years with NUMSA, SACAU, NUM, all those trade unions, your work with young people, and the other good things you've done. But then they've turned around and actually support your candidacy. So
yes, I noticed
all's
that.
well that ends well. But then there had also been this issue that you had only acted for a very brief spell and could perhaps benefit from a longer acting stint, which now seems to have been addressed. But let's see.
Yes.
I will stop here, Ms. Ravi, and hand over to JP Mulasehi to put any questions he might have for you.
Thank you very much, and good morning, Chief Justice, and
Good morning, Jay.
good morning, Commissioners. Good morning, Ms. Harvey.
Morning, JP.
I don't have many questions for you, but just maybe let me start with the language issue. I think there's consensus that there's a need to bring all other languages to the same level as English. But shouldn't we be doing the very basics, trying to walk processes like in the court, especially in the labor court, the majority of our users are lay litigants. And they come there speaking Tswana. You speak Setswana quite fluently. Now, if they address you, should they be saying my lady? Which is a concept that I find even those who speak English sometimes struggle with. They refer to our women judges as my lord, and then they correct themselves, my lady. Isn't that something that we should look at? Because sitting in the labor court, I always find people who speak Zulu, for example, they'll be saying, Mhlali wa Kantoro. And you have an advocate who speaks Zulu, who's Zulu. Shouldn't we be encouraging that as a kind of a symbolism that this language is also as important as any other language?
Yes, I would totally agree with that. Are you saying that one could bring in certain phrases in all South African languages whilst still maintaining English as the main language of record?
Yes.
If you're suggesting that, I would certainly support it because, as you say, the concept of my lord and my lady, they're very much English concepts, English as in the UK. So I also find it very strange. I very much like the fact that in the Constitutional Court we refer to judges as justice. That seems to describe their position better. But yes, bringing in those linguistic changes would certainly be a first step.
Yes, thank you. And you are currently acting at the labor court now.
Yes.
And you doing urgent court this week.
This week I've been on urgent court, yes.
And our urgent court is on for 24 hours.
Yes.
The last time I checked, yesterday before I left, there was a restraint that came in. How did you manage to deal with it? How are we dealing with those cases that are supposed to be continuing this morning?
Well, the cases on my roll that are supposed to be continuing this morning have been reallocated. The acting DJP very kindly intervened on my behalf and took those cases and reallocated them to somebody else. So that's how that's been handled. Yes, in terms of just dealing with cases coming in at the last minute, it's important that people have access and that they be heard. The fact that things come in now on case lines means that one has to wait for the matter to pull through. I had a case like that, I think it was on Wednesday, where it literally only pulled through about an hour before court was to commence. And I had to just stand that case down for 2 hours in order to read the papers. Yes. But I think that the court online system is helping because it's all there online and everybody can access it through their own device. And certainly on urgent court, one just does one's best to read and to hear and to hopefully to resolve the issue as fast as possible.
Yes, it's actually the senior judge, not the ADJP, that they agreed to take over your matters. But it's quite important for the commissioners to also understand how things are working at the labor court. They're always concerned that court must function effectively, continuously, and the working between the judges. Where was this issue discussed about the the senior judge coming in, and I know that even Thursday, I just overheard it as I walked into some room that somebody else was going to take over your matters.
Yes, JP, that is in the tea room. And we discussed the tea room last time I was here. I have been attending the tea room every single day. And as you pointed out to me, Judge President, it's an invaluable step to take because it puts you in touch with other judges. You can discuss your matters with them. And as you've just pointed out, matters can be reallocated and shared. In fact, there was a case on my urgent roll on Wednesday, which I was ready to deal with. But when I arrived in court and looked at the service affidavit, I realized that service hadn't been properly effected. And I was able, instead of removing the matter from the roll completely, I was able to find another judge who was able to deal with it the next day, pending proper provision of that service affidavit. And that wouldn't have been possible without the tea room collegiality in the Johannesburg court.
Thank you very much. The other thing you spoke about training. I'm sure you're aware that we're now relying quite heavily, unfortunately, on pro bono. Thanks to the willingness to support from the profession. Now, some of the profession has asked us to, particularly the bar societies have asked us to do training. Is there something that you think you could contribute, and what is your view about us as judges going there and putting aside a weekend to go and conduct those trainings? And also, what is your view about us training also in the CCMA?
I think it's absolutely essential, Judge President. Obviously, it would be ideal to have mostly permanent judges and for there to be pro bono and acting judges only for the purposes of filling in gaps and I suppose for sort of pipeline for training potential future judges. But at the moment, given the backlog and the amount of pressure on the labor courts, I support the initiative to invite as many acting and pro bono judges as possible. And then, of course, it becomes especially important to train and support those judges. In fact, a pro bono judge was allocated to the double chambers that I'm in at the moment, and he approached me for assistance on a few occasions. And weekend training, even better than approaching a judge at 9 o'clock in the morning while they're preparing for their own matters. I think that's important. Personally, I love training. I enjoyed it when I worked for the CCMA. I've enjoyed it working for the legal NGOs. I would be happy to give weekends to training, although maybe I shouldn't speak too soon, given the judgment load. And then you mentioned CCMA training. I think that's also very important. You know, when we first established the CCMA, that first cohort of commissioners received extensive training in the new Labour Relations Act. And I think the quality and the standard was very high. And because we were all pulled from trade unions and the TRC and people who were active in the labour movement space at the time, I think we all really understood the constitutional project of the LRA. And I think that has been watered down over the years. And there are now people in the CCMA who have diplomas, but possibly not the social context clear in their backgrounds. And that was something that I worked on a lot when I trained CCMA commissioners as a commissioner myself. And I wonder sometimes whether the review judgments of the labour courts are intensively revised with CCMA commissioners, and I think that would be an invaluable contribution to the quality of awards coming up. And the better the awards from the CCMA, JP, the fewer reviews will be brought to our court and the lesser the backlog should get.
Yes. You attended the wellness seminar, which was done at lunchtime.
Yes, JP.
And I'm sure you suddenly heard the horrors of the workload of the Labour Court. What's your view on that? Especially that, if I may remind you that at one stage you had a big matter to deal with and I walked into your chamber and said, I've got a file here that I wouldn't want it to be postponed. This person comes from far. What, what would you say to that approach?
I remember having that very large, I think it was an ESCOM matter, JP, which required a lot of reading. And you came and asked me to do a leave to appeal. And I think I said to you I wouldn't have capacity to deal with it until the next week. But yes, there is a huge workload, JP, and I think that's why that wellness seminar was held. As an advocate, I think I have already learned how to manage my time and how to manage my personal wellness in exactly the ways that were being discussed. Taking down time, making sure that one remains physically healthy, exercising, going through stress reduction techniques. But one also needs to develop a clear discipline when it comes to being prepared and to producing judgments. And I think that I have been thinking about this, about how I will manage the workload if I am appointed. And one of the most important things, I think, apart from being prepared and working hard, are doing judgments quickly. I certainly found as a CCMA commissioner and also as an acting judge that the longer the period that elapses between the hearing and the writing of the judgment, the more difficult it is to write the judgment. As CCMA commissioners, we were required to produce awards within 10 days. And although that put a lot of pressure on us, I think it really helped to support the quality of decision making. And as an acting judge, I think that if possible, I will try to hand down judgments as immediately as possible, because I really have discovered that the longer that I leave it, the more difficult the decision-making process becomes.
I'm not going to ask you about your judgment writing, something that I need to sit down with you to share with us as to how you managed to get your judgment so quickly out. But let me ask you also this, and probably to relate to it. Have you attended the lunch seminar which the acting judge president Mahalelo keeps throwing at us almost every week? I find it so heavy burdening. What's your view there? Have you attended it, and what do you think the value of that is, if you have?
Sorry, which seminar is that, JP?
The lunchtime seminar. Not so long ago, she had arranged for, or you probably were still not yet acting, but she arranges regular seminars on various topics. Recently, it was a whole issue about the restraint of trade and agent application, because our rules very difficult to apply in as far as restraint are concerned. That's my view. Other judges hold a different view.
I haven't heard about those lunchtime seminars.
Okay.
I would really welcome them. As a SASLAW member, I've often said that we're lucky to be labor lawyers in an environment where there are frequent workshops and updates on the law, because otherwise, as a practitioner, you only update yourself on the specific cases that you're handling at the time. So regular updates on case law and the proper approaches to different types of disputes, I think, would be invaluable.
Yes. The last question for me, Chief Justice, last time you did indicate that you're quite happy to travel because the Labour Court judges travels across the country. But now we're working on actually trying to establish a footprint in each of the provinces. You realize that the traveling may actually be extended. If you're in Cape Town, we're likely to send you to George. We're likely to send you to Mafikeng in Northwest, and Limpopo we already established fairly. We're not yet satisfied that we're fully operational, but there's a regular attendance at that, in that province.
Yes, JP, I think I mentioned last time that I am happy to travel. I am now based in Johannesburg. I live here now. This is my home. If I'm asked to act in other centers, I will enjoy it. And I think I mentioned last time that when the CCMA also used to send us around the country, I really enjoyed it because the personality of the types of disputes that come before forums in different parts of the country are different. And that is always entertaining and engaging and interesting, and I do like that.
Thank you, Chief Justice.
Chief Justice. You're fine.
Thank you, CJ. Ms. Harvey, my question is a non-qualification question, rather benign, not like the tea room attendance one last time. But you stated in your introduction that you'd spent some time with the ANC in exile and you'd had discussions with them about your tertiary education qualifications. But in your application, where it says, please furnish particulars for your membership of any political organization, past and present, you've said none and not applicable.
I suppose I didn't consider myself officially a member because the ANC was a banned organization at the time. That's the best answer I can give to that.
And maybe you should have said something about it, but it's something that we raised with you on the last occasion, and you explained your involvement fully. It is in the transcript. Was that the only question? All right. Commissioner Hassan?
Thank you, Chief Justice. Ms. Harvey, thank you for coming back to the JSC. My question is a little bit more around the future and what it might look like. We're entering a world in which algorithms now have the ability, and in some instances are hiring, they're monitoring, and they can even dismiss workers. And the traditional concepts of employer, employee, and even a workplace has been quite stretched by these different AI-driven platforms, and even remote working and remote labor. So from a judicial perspective, how do you think South African labor law should potentially evolve to protect fairness and dignity in this changing world of work, but at the same time not stifling innovation and what could come from that? Thank you.
Thank you, Commissioner. The guiding principle is in the Constitution, and it promises fair labor practices to everybody. That said, the world of work is changing. As you mentioned, I think you mentioned AI. There's also a lot of gig economy work and more precarious or non-standard employment. And it's becoming apparent that the LRA, which was designed in 94, 95, it presumed a number of things. It presumed, for instance, long-term, stable, career-based employment. And it also presumed a strong trade union movement which could advocate for and protect the rights of employees. And what we found now is that our labor law is to some extent becoming misaligned with the realities. The trade union movement has diminished, it is less strong, and I think that is, at least in part, if not wholly, because of the changing nature of work. Trade unions, which had traditionally structured themselves around the permanence of work, the fact that there could be full-time shop stewards, people who could be trained, who would stay in workplaces, the outsourcing of work, the platform nature of work, all of that has undermined and weakened the traditional way in which trade unions have organized. And I think that alternative forms of worker organization are inevitably going to emerge, and our law is going to have to adapt to accommodate them, because workers need to collectivize in order to enforce those rights to fair labor practices. As you may well know, I've worked on one such case, the Simunia Workers Forum case. And a few years ago also, I worked on the first Uber case, which was brought, in which the question was whether or not Uber drivers were employees. That iteration of the Uber case kind of fell through on a territorial jurisdiction point, which was a pity. But I believe that a new challenge is being brought, and that's going to mirror these developments around the world. So I think that our law is going to have to develop in response, and I hope that it doesn't lag too much behind. I think at the moment it is lagging a bit, and we all know that law reform takes time, but those things are definitely going to need to be addressed. Otherwise, we're going to find a complete disconnect between the world of work that South Africans are in and the legal framework that judges are applying.
Can I make a follow-up, CJ?
Yes.
Thank you, CJ. Good morning, Advocate.
Good morning, Commissioner.
Just on the point that you raised around the diminishing of the strength of trade unions or trade unionism, do you think that the alliance that the unions has forged, as an example, citing the alliance that COSATU has forged with the ruling party, could be an obstacle to the maximum one country, one federation? And do you think that there has to be a relook at that? But at the back of our mind, take into account the fact that the distinguishing factor between, let's say, between SACTU and other unions was their belief that before you are a member of a union, you are a member of your own community. So therefore you can't just restrict yourself to shop floor issues. You have to address the issue of the bread and butter issues of your own community. Thank you.
I'm not sure that I'm following the question, but to the extent that you're looking at the tripartite alliance, I think that I don't know whether the alliance between unions and political parties is what has contributed to the weakening of it. I actually do think that the changing nature of work is what has done that. And right now we're sitting in a situation where I believe the latest statistics are less than a fifth of South African workers are unionized at all. And in a situation like that, it becomes less and less relevant, I suppose, what the federations do.
Commissioner Mermogai.
Thank you. Thank you, CJ.
Thank you very much, CJ. Good morning, Advocate Harvey.
Morning, Prof.
It appears to me, I'm not sure if I'm correct, that there are violations of labor rights in the agricultural sector. And farm workers are arguably the most vulnerable because they face evictions, casualization, and exploitation, and all those goes to the fact that they are employed in these farms. There are several legislation in South Africa that tries to deal with labor rights: LRA, BCA, QUEDA, SDA, and various pension legislation, and the constitution on top of that. I'm just wondering, what is your view, if any, on this fragmented legal regulation of employment in South Africa, and whether it is adequate in addressing challenges that are faced by farm workers in this country? And in addition to that, do we need activist judges who really understand the plight of farm workers in this country? And I'm asking that based on your background, of course. Thank you very much.
Thank you. Definitely, the law is not reaching. We need fairness. We need fair laws, but we also need fair reach. And it's not just farm workers, but they are a big part of the precarious mass of workers. It's also precarious industrial workers, non-standard workers, and in many instances, with both farm workers and precarious industrial workers, it's women workers who really cannot access the vast raft of rights that are set out in our labour jurisprudence. I'm thinking now of my work through the Casual Workers Advice Office. It has alliances with farm worker organizations. And I'm thinking of the many, many working women in our country who are single mothers, who have to take sorry, I think the mic went off. They have to take whatever work is available, even when that is when it requires sexual favors, even when it requires working overtime without pay, and they're unable to, although they know their rights, they're unable to enforce their rights, because in enforcing their rights, they will very likely lose their only source of livelihood. And so one of the things that we need to do, it's not something that judges can directly do, but is to make sure that the law starts to close the gap between the existing rules and people's ability to actually access those rules and make them real. And when you talk about activist judges, yes, I do think it's important. It's part of transformation of the bench. It's important to have a diverse range of voices and experiences and backgrounds on the bench, so that a diverse range of voices and experiences can be heard by the bench. To the extent that the bench can develop the common law and interpret existing laws through the lens of the Constitution, all judges are duty-bound to do that.
I am more concerned about farm workers, and particularly those that are subjected to zero-rated contracts. And I just want to get your view whether these kind of contracts should be regulated by the LRA, or we should leave the situation as it is now. As far as I know, there is only one award that was handed down by the CMA. Apart from that, I have not seen anything that deals with zero-rated contracts in South Africa.
Yes, these zero-hour contracts, I think what you're calling zero-rated contracts, it's a contract where you contract to work for somebody, but you're not guaranteed any number of hours, which seems to be completely at odds with any notion of human rights, because you're required to make yourself available for work, I suppose at your own expense as well, but you're not guaranteed any minimum hours. And yes, I do believe that legislation should address that. I think it was a gap in minimum wage legislation. Minimum wage legislation legislates a wage per hour, but that then is interpreted as only being if you work for that hour. Minimum wages should provide for a basic living wage for anybody who works per week or per month. Otherwise, it becomes meaningless if one's only going to be given 1 hour's work.
Thank you very much, Advocate Harvey. Thank you very much, CJ.
Commissioner Mangen?
Thank you, CJ. Good afternoon, Advocate Harvey. Good morning.
It's been a long week.
It has been a long week, indeed. I'm encouraged by the fact that you come from the trade union movement. Now, the Labor Relations Act has at its center the notion of fairness to both the employer and the employee. And with regard to dismissal, the jurisprudence that has been coming from the Labour Court and CCMA awards suggested that the country has rejected the reasonable employer test on dismissal. But what we are seeing now, recently with regard to certain judgments, it's like there is a reversal of that jurisprudence, and judges and commissioners are reverting back to the reasonable employer test in the determination of whether it is fair or not to impose the sanction of dismissal. Instead of looking at fairness, they look at what a reasonable employer would do. And as I read the Labor Relations Act, I do not think that is right. Am I correct in that assessment?
I don't think I've noticed that trend. I think it's been very clear since Sidumo that it's fairness, and to the extent that fairness is a value judgment, it's the commissioner's sense of fairness that determines whether a dismissal is fair or not the employer's sense of fairness or sense of reasonableness. But maybe you've read something that I haven't, and I'd be happy to engage with that if that's the case.
But do you accept that the Labor Relations Act rejects the reasonable employer test in the determination of the fairness of the dismissal.
Absolutely, because that test is a deferential one, and there should never be deference. Fairness, as you've pointed out, is a matter of fairness to both sides. And the context is important. The imbalance of power, for instance, is important contextual information.
Thank you, Advocate Harvey.
JP Tlalesi?
Thank you, Chief Justice, and good morning, Advocate Harvey.
Good morning.
I recognize you, LAC assigned matter. Yes, just to explain something that causes confusion at times. Is there any distinction between the powers of the labor court and the jurisdiction of the labor court? How would one describe that? Thank you.
Those two things do get mixed up from time to time, Commissioner. Section 157 sets out the powers of the court, and Section 158 sets out its jurisdiction. Jurisdiction refers to the matters that the court may apply itself to. There are certain matters that fall outside of the jurisdiction of the labor court, and it won't be seized with those matters. The powers of the labor court refer to the powers that it can exercise once it is seized with jurisdiction, and those include powers of, those include the kind of remedies that the labor court can grant. That, in my understanding, is the difference between powers and jurisdiction.
Thank you, Chief Justice.
DP Zwane?
Thank you, Chief Justice. Morning, Advocate Harvey.
Morning.
My question to you is just a simple one. Now, you've alluded to the fact that the unions now are sort of less powerful. And in terms of Section 161 of the LRA, the employees may be represented by the office bearer of the union, either at the CCMA level or at the labor court. Now, the fact that the unions now are sort of less stronger than they used to be in the 1990s, I'm talking about the union like SACAU, FAU, SACTU, NUM, NUMSA. Those unions used to have a very good shop steward who represented employees effectively, either at the CMA level or the labor court. Now, with the unions now having become sort of less in terms of, well, weak in terms of their power, how have you found the quality of legal representation provided by the office bearer of the union, like the shop steward? And if the quality of legal representation has been compromised, are you aware of it? And how do you assist the litigant to make sure that they receive proper representation or assistance in terms of presenting their case?
Yes, thank you for that question. That is something that has really concerned me a lot over the last years. The quality of representation by union officials when they have appeared before me in the labor court has been good, but it has only been the biggest and the most well-resourced unions, usually in the public sector, who do send union officials to court, and those union officials are, in fact, it's usually officials and not office bearers, and they usually are excellent. But as you point out, the union movement that existed at the time that the LRA was crafted was a union movement that had in its ranks large numbers of highly skilled and trained and competent shop stewards, officials and office bearers. And I do believe that the LRA was designed on the assumption that that situation would continue. And indeed, the dispute resolution functions of the CCMA are dependent on having that quality level of rigorous, highly trained, highly competent officials in the trade unions. At CCMA level, Rule 25 provides that workers may only be represented either by a lawyer in certain instances or otherwise by an official of a registered trade union, and that's where the first problem comes in. More than 4/5 of the workers who bring disputes to the CCMA do not have a registered trade union and cannot afford a lawyer, and that means that they cannot be represented according to the way Rule 25 was. In 2016, we brought a constitutional challenge to that rule to the Labour Court. The matter wasn't heard, but in fact there was a settlement agreement, and subsequently the CCMA amended its rules, but only insofar as it now allows for a discretion. Commissioners now have a discretion to permit alternative representation in a given case. And that rule ought to now open the door for community advice officers and other community organizations to assist workers in the CCMA, but we're finding in practice that the discretion is exercised haphazardly, and that most of the time workers do find themselves unrepresented in the CCMA. You asked about the Labour Court. I'm very familiar with dealing with lay persons because I was a CCMA commissioner for a long time. I'm not uncomfortable dealing with lay persons in my court. I have found that it is very seldom that a lay person does reach the Labour Court. And I think that's partly because people just don't know how to access it. And through all of these other levels, including through the CCMA, they just haven't been able to access representation. But when a lay person is in my court, I feel quite comfortable. I, for many years, had to work with the difficulty of assisting a lay person without supporting their side of the case. It's a fine line to walk, but I believe one develops the ability with practice. But this is one reason why I've worked so hard to build alternative employment law capacity in the legal NGOs, the public interest NGOs, because of that diminishing ability to represent workers by the trade union movement. At a certain point, even Legal Aid SA didn't have an employment law department. But now I've seen that Legal Aid SA is starting to appear in the courts, which is a good thing. And I've worked very hard to establish labor law capacity at the, there's a new labor law unit at the Lawyers for Human Rights that I've been involved in mentoring and training those attorneys. LRC has also taken on some labor law matters. And so through a combination of hopefully supporting the rise of a new trade union movement that suits the needs of modern workers, plus developing capacity in the NGOs, hopefully in the next few years we'll see a reversal in that pattern where workers are not properly represented. But when there are laypersons, it does pose difficulties. They do need a lot of explanations and support. And of course, with a very busy and burdened labour court role, that can slow things down a bit. But at the end of the day, the main principle is that everybody must have access to court. And when they get there, they must be treated with courtesy, and the procedures must be made accessible and understandable to them.
Thank you, CJ.
Thank you, TP. There are no further questions for you, Ms. Harvey. Thank you very much for not giving up on us, and all the best. You're excused.
Thank you, CJ and commissioners.